Your Honor, who's the case manager on today?
Holly Bridgewater.
Thank you.
Okay. All right, we'll go ahead and get started. Good afternoon, ladies and gentlemen. My name is Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals who have been recently arrested and charged with certain misdemeanor offenses are brought before the court. Soon after their arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address several matters, including bond, possible arraignment, or consideration of a possible plea offer if one has been made by the state at this juncture. I will be providing individuals with the reset date, and that reset date for SAP is March the 10th, 2022. I'm going to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. I also want the persons on this calendar to be reminded that you do have a constitutional right to remain silent. Anything that you say about the facts or occurrences and the circumstances of your case, those statements can and will be used against you. The solicitor is on the Zoom court and they are listening, so be careful, adhere to your attorney's instructions. And we're going to start, are we starting at the South Annex or courtroom 2?
Let's start at courtroom 2, Your Honor.
Okay.
We got position number 6, Mr. Lee Kent.
Okay.
And Your Honor, I attempted to speak to Mr. Lee Kent this morning. I suspect he might have some mental health problems and doesn't quite realize whether he needs assistance from an attorney. I would be fine representing him for the purpose of bond hearing today, depending on what he says. Also, if the court would like, I've spoken with Mr. Howard about this. If the court would find it necessary, I could, I have a motion order and referral for evaluation to potentially send. I spoke with the officer and he had some mental health concerns.
Okay. So are you wanting to go in a breakout first, or just let's see what Mr. Lee Kent has to say regarding your representation?
Let's do the latter. He at first said that he wanted me to represent him, then said something about per se, and I couldn't get him back on the phone, so.
Okay, let me ask real quick. This is case number 22 CR 01078A. And you're Mr. Sage Lee Kent, is that correct?
Yes.
Okay, and you're being charged with 1 count of criminal trespass, a 2nd count of obstruction of law enforcement officer, and a 3rd count, well, there are 2 counts of obstruction of a law enforcement officer, all with the offense date of 2/25/2022. And so, Mr. Lee Kent, I need to first ask you, are you going to go forward with the services of the PD's office?
I would like to represent myself.
You want to represent yourself?
Yes.
And you know that there's going to be challenges with that, and you're required to know the rules of court. You are being provided services of the PD's office today just for this bond hearing purposes. I suggest that you may go with that because that may bode you a little better to get some professional representation as opposed to representing yourself. And you do understand any statements that you make regarding your case, those statements can and will be held against you. So you need to act accordingly, but you are to know the rules of the court. So which would you like to do? Would you like to either retain your own attorney that can reset your case, or you can go forward with PD, or you can go forward and represent yourself, which I don't recommend, but I will let you do what you choose that you want to do today.
I would like to represent myself.
Okay, you still want to go forward and represent yourself?
You gotta answer it, Ken.
I would like to represent myself.
Okay. All right, we will go ahead with my concerns with that. I'll go ahead and let you represent yourself. All right, we're going to start with the state first so they can present the case. Okay. All right, go ahead, Ms. Sari, is this your case?
Yes, Your Honor, and good afternoon.
Good afternoon.
Your Honor, in this case, officers responded to 1500 Donald Lee Hollowell Parkway to serve an eviction when the defendant refused to leave. He ran up to the attic with something slung across his back, and then officers stated that they heard a noise that sounded like someone putting a chamber in a round into a weapon. The defendant was then apprehended. Your Honor, this defendant has a 2014 obstruction charge, a January 21st disorderly charge that's still open, and a February 7th theft by taking that's still open. Your Honor, this defendant, due to his history where he still has open charges from 2 arrests within the last month, he does present a risk of reoffending. And due to the facts stated above, the state is recommending a $5,000 surety bond with conditions of staying away from 1500 Donald Lee Hollowell Parkway.
All right, what is the breakdown of your of your bond recommendations on the 3 charges?
Sorry, Your Honor, that's correct. So a $2,000 bond, surety bond on the criminal trespass, $1,500 for each obstruction charge.
Okay. All right, and I'm sorry, Ms. Harrison, I did not ask about pretrials or anything that you have to add. I apologize.
Yes, GCIC indicates 10 cycles with 3 cycles out of Pennsylvania. Last arrest was February of this year for theft by shoplifting in Dunwoody, Georgia. No disposition listed in that arrest. He has 2 convictions in Pennsylvania, 2016 violation of controlled substance and cosmetic act. It's a felony, and a 2016 aggravated assault 1 and aggravated assault felony 2, reckless endangerment felony, robbery, and possession of instrument of crime. Nothing further to add.
All right, thank you. All right, Mr. Lee Kent, I want you to tread very lightly here. And let me just ask you a few questions. How old are you?
I don't know.
You don't know? All right, do you work?
No.
Do you receive any type of income each month from any sources?
Yes.
Okay. Social Security, disability, or something like that?
No.
Okay. And do you you were residing at this 1500 Donald Lee Hollowell? Is that where you used to live?
Yes.
Okay. So have you found new housing or a place to stay? Do you have a place to stay?
Yes.
Have you provided that address to someone so that we would know where to send additional court notices?
Yes.
Who did you give that new address to?
The correctional officer.
to the correction officer there at the jail. I'm going to possibly see if they can put your new address in the chat because we would need that information regardless of where you would be staying.
Your Honor, as soon as he give it to me, I'll put it in the chat.
Okay. All right. Is there anything else you would like to state?
No.
Okay. All right, I'm going to order a $5,000 surety bond. That is $2,000 on the trespass, $1,500 on each obstruction charge. I'm going to order you to stay away from 1500 Donald Lee Hollowell Parkway. I'm going to order that if you're out on bond, that you would have no drugs, alcohol, or weapons while on bond. And you are to stay away from that address, Mr. Lee Ken. If you go back, you can be arrested. So that's going to be the ruling of the court today, okay?
Yes.
All right. Thank you.
Thank you.
Your Honor, did you want me to submit a referral or not at this time?
Does the state have anything to say about that?
No, Your Honor, the state has no objection.
Okay, yes, you can submit the referral.
Your Honor, next we have position number 2, Mr. Andrews.
Okay,
And may I add, Judge, for them to send it to my attention so that I can forward it to you.
yes, all right, that's Holly.Bridgewater. Okay,
Thank you.
all right, thank you. This is case number 22 CR 001075G. Are you Adonis Andrews?
Yes, ma'am.
All right, you're being charged with 1 count of theft by shoplifting with the offense date of September the 2nd, 2021. Do you have anything pretrial?
Your Honor, 30 cycles with history in Georgia and Florida. Last arrest, September of 2021 for criminal damage to property, 2nd degree. That was a conviction. Record indicates the defendant has a 2018 terroristic threats, misdemeanor conviction, 2 convictions in 2018 for theft by shoplifting, a 2018 criminal trespass, 2017 theft of services and giving false name, and a 2017 misdemeanor theft by taking and criminal trespass. He has a 2017 misdemeanor conviction out of Florida for criminal trespass and 7 violations of probation. 7 failure to appear and 1 violation of probation within the past 10 years. Nothing further to add.
All right. Ms. Sorry.
Yes, Your Honor, in this case, officers responded to a theft by shoplifting call at Kroger. The defendant was seen taking cosmetic merchandise from the shelves of the store. When the sales associate attempted to stop the defendant, he fled. The associate stated that the defendant comes in every couple of weeks and shoplifts. Your Honor, due to the defendant's history, we've heard multiple convictions of theft by shoplifting and also theft by taking. The state is recommending the bond is already set at $2,000 and the state is recommending it remain as set, as well as an MHET and a stay away from Kroger. That's 3330 Piedmont Road in Atlanta. And Your Honor, that bond recommendation and as well as the other conditions are based on the defendant's history, his arrest. He presents a risk of reoffending and not appearing for his court date, as it appears he does not have an address on file.
Okay. All right, Mr. Coleman.
Your Honor, I'd be requesting a signature bond for Mr. Andrews. Looking at his paperwork, it looks like this warrant was issued on September 2nd of 2021. He was arrested on September 30th of 2021. Although there is a bond, I'm not exactly sure when that bond was set. I think this may be the first time that he's actually appearing before this court for a bond hearing. That being the case, some 5 months later, he will be entitled to a signature bond under Riverside. I think that he's being held on felony charges. I don't know what the bond amount is on that felony or what that felony may be. But again, I would be requesting a signature bond if he's just now first appearing before the court on the misdemeanor charge.
Okay. Do you have any information on that, Ms. Sorry?
No, Your Honor, I don't have any information on the potential hold.
And you don't either, Ms. Harrison, you don't see anything?
I'm not showing a hold, Your Honor, in his GCIC.
Judge, I've been in here for 5 months on a criminal damage to property, and this is the first time I've been to court for the misdemeanor. I've been in
Yeah,
here.
according to the paperwork I have, again, the warrant was issued on September 2nd. He was arrested on September 30th on these charges. But again, if this is the first time he's appearing before court on a misdemeanor, he will be entitled to a signature bond.
Okay, so that September 30th of 2021 criminal damage, that was a conviction. That case number is 21 CP 203442. That was his last arrest.
Okay.
And Your Honor, if I may, just based on his history, that's where the state is recommending the bond remain as set because of those convictions. He does present a risk of reoffending.
Mr. Coleman, do we have an address or anything?
I do not. I believe he is homeless. I just have a contact number for his mother.
Do we have the mother's address? Is she here in Georgia?
Yes, ma'am, she is.
It is a local number.
Do you by chance know her address, Mr. Andrews?
Yes, I know her address. Her address is 711 Fitzgerald, Fitzgerald, like Ella Fitzgerald Place. And that's in Atlanta, Georgia, 30349.
And you're able to receive mail there?
I am.
Okay. All right, I'm going to grant a $2,000 signature bond through the jail.
Thank you.
I'm going to order that you stay away from the Kroger at 3330 Piedmont Road. If you go back to the Kroger, you'll be immediately arrested. You seem to, as the statements were made, be irregular there, but we want to stop that.
Yes,
So
ma'am.
do not go back to the Kroger or anywhere else for that matter to shoplift or anything. I'm going to order that you have no drugs, alcohol, or weapons while on bond.
Okay.
And this case is further notice. Is that right, Ms. Bridgewater?
Yes, it is, Judge.
You're to keep your address current with Mr. Coleman and the clerk of court so that you will receive future notices regarding your court date.
Yes, ma'am.
I'm not going to order the inmate GT at this point. And I don't know if there's anything else I need to take up at this point, Mr. Coleman or Ms. Sorry.
No, Your Honor.
Okay,
No,
All
Your
right.
Honor.
that will conclude this. Good luck to you, Mr. Andrews.
I'm like,
We have position number 3, Mr. Jonathan Bradley.
This is case number 22 CR 001077Y. Jonathan Bradley, you're charged with 1 count of simple battery family violence. The offense date of August the 14th, 2021. Is there anything pretrial?
9 cycles, last arrest, January of 2021. for failure to appear in Sandy Springs. Underlying charge was not indicated. Record does indicate the defendant has an open case pending in Fulton County for driving while license suspended, knowingly suspended. That case is in dormant bench warrant status, 17 CR 013849A. Record indicates 2 failure to appear within the last 10 years. Nothing further, Your Honor.
All right, Ms. Sorry.
Yes, Your Honor. On August 14, 2021, officers responded to a dispute where the victim advised she had been choked by the defendant after she grabbed his phone in the defendant's attempt to retrieve it back from her. The victim did state she did not lose conscious or gasp for her breath. Your Honor, we've heard from pretrial that there are a number of FTAs, and due to those failure to appears, the defendant does present a risk of not appearing to the next court date. Your Honor, the state is recommending a $2,500 surety bond, no contact with the victim, Shaquita, CHIQUITA Sims, SIMS, a stay away from 201 Maury, MOURY Avenue Southwest 30315, that's in Atlanta. Nothing further.
All right. Mr. Coleman.
Yeah, I would be requesting a signature bond from Mr. Bradley. He is 56 years of age. He is a high school graduate, currently employed at Denali Solutions Water, father of 1 child, age 15. Looks like this warrant is from August 14th of last year. He has 9 cycles, but I did not hear any violent charges in that criminal history. Reading the warrant, it does not appear that the alleged victim had any visible injuries. I will remind the court at this time that these are just allegations against Mr. Bradley. I will be requesting a signature bond.
Okay. All right, I'm going to order $2,500 surety bond. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order no further contact with the victim, Shaquita Sims. I'm going to order stay away from 201 Maury Drive, Atlanta. And I think that should conclude everything. Anything else?
No, Your Honor.
Good afternoon, Your Honor. This is the South Annex, and we have before you position number 1, Ms. Ali.
All right, thank you. This is case number 22 CR 001073A. Quinteria Ali, you're charged with 1 count of criminal trespass with the offense date of December the 4th, 2021. Do you have anything pretrial?
GCIC indicates no prior history. She does meet the criteria for UJR through pretrial. Nothing further.
Okay. All right, Ms. Sari.
Yes, Your Honor. In this case, witnesses saw the defendant throw an object at the victim's car windshield, which caused it to shatter. The victim did present repair receipts for his windshield. The defendant and the victim only know each other because the victim's girlfriend's daughter and the defendant were in a previous romantic relationship. Our office was able to speak with the victim. He could not attend the hearing today. Due to the facts stated, the state is recommending a $1,500 surety bond, no contact with the victim, Darren, DARRIN, Davis, and Sheniko, SHENIKO, Winfrey, WINFREY, and a stay away from Pavilion Place Apartments, That's 532 Cleveland Avenue Southwest, Atlanta 30315. Nothing further.
All right. Mr. Coleman?
Your Honor, I will be requesting a signature bond from Miss Ali. This appears to be her first arrest. She is 22 years of age. This warrant appears to be from December 4th of last year. She is a high school graduate, currently employed at Chime Solutions. No children. Again, I'd be requesting a signature bond if this is her first arrest. Nonviolent offense.
And does she reside somewhere different than this apartment complex?
She lives with her aunt.
Okay. All right, I'm going to order a $2,000 signature bond through pretrial. I'm going to order that there be no further contact with the victims, Darren Davis and Shaniqua Winfrey. I'm going to order that there be a stay away from the Pavilion Apartments at 532 Cleveland Avenue Southwest. And I'm going to order that she take the one-day anger awareness course with pretrial. No drugs, alcohol, or weapons while on bond. And I think that concludes everything. Anything else?
No, Your Honor, thank you.
Uh-huh.
We have position number 7, Mr. Henry Spark.
This is case number 22 CR 001079E. Mr. Henry Spark, you're charged with 1 count of DUI, driving under the influence less safe, and a 2nd count of failure to yield right of way to vehicle, both with the offense date of February the 25th, 2022. Do you have anything pre-trial?
Your Honor, no prior history. He does meet the criteria for UJR through pretrial.
Okay. All right. Oh, Mr. Borger, how are you?
I'm well. How are you, Your Honor?
Good.
Good. Thank you, Your Honor. In this case, the state is asking for a $5,000 surety bond. That's $3,000 for the DUI, $2,000 for the failure to yield. Your Honor, in this case, the defendant was pretty intoxicated following a traffic accident where the defendant had hit another vehicle. Field sobriety tests were performed, and the defendant totally failed to follow directions correctly, and just seemed to not have a good understanding of the severity of what had happened, or let alone what had happened in general. Due to the fact of his high intoxication, the state does think that a $5,000 surety bond would be appropriate, along with the conditions of no driving without express permission from the DDS, and no drugs or alcohol while on bond. Nothing further from the state.
Okay. Right, Ms. Bronstein?
Thank you, Judge. Mr. Spark is 47 years old. He resides in Atlanta. He is a college graduate, and he actually works in corporate commercial banking as a portfolio manager, and he has been in that line of work since 1995. I'm representing him for the purposes of bond today. He has not had a chance to hire a private attorney yet. As pretrial stated, he has no prior arrests. In Odyssey, so his girlfriend had already actually been speaking to a second chance bonding company. In Odyssey, I don't know how this got in the system, but it says recommended $1,000 bond for the DUI and $265 for the failure to yield. So those are actually the numbers that he was given, and his girlfriend had been discussing with a second chance bonding company. we would ask that the court either go with that or potentially pretrial. Also, as far as driving, no driving without the express permission of DDS. The officer, if they.
Excuse me, PD, I'm sorry to interrupt you, but he had already posted bond on these charges.
Oh, okay.
So yeah, she did go through the second batch. He just hadn't not been processed out. So he has
Okay.
already made bond on these charges.
Okay,
He just haven't been processed out yet.
okay. So we can stop and he can go forward with the bond. And then there was already conditions, I'm assuming, on there as well, correct, Ms. Lewis?
No, the bond, apparently, when he got arrested, there was already bond set for him on these charges.
Mm-hmm.
So he already posted bond on these charges. I mean, if you want to add conditions to the bond that you have, that you want to what he had already bond out, that's fine. But the amount is already set.
And I would ask to not add the driving condition if the officer wants to try to revoke his license, but pursuant to the hearings and everything, they can certainly do that. I've never seen a revocation of license without express permission. Either the officer goes through the process to try to revoke or suspend a license prior, or they don't, and the license remains valid. So I would just ask that that process go as it normally does.
I mean, normally I understand what Ms. Bronstein is saying. I mean, I know that this court does have the power to suspend driving until given permission from the DDS. So, I mean, functionally, his license would just be suspended, and then he could apply for a limited permit for that matter, and the DDS can choose to approve it or not. But the fact of the matter is he is accused of a DUI, and based off of the fact that it's DUI less safe, he likely refused the intoxilizer, didn't get blood. So his license should be suspended regardless.
That's what I was gonna say. I understood. I think it's automatic suspension.
That runs, correct, that runs if with the implied consent.
Right, it would be scheduled for a hearing for a suspension pursuant to the implied consent.
Okay, okay. Well, we will move forward and go with the bond is set, and he will see what else he needs to figure out with his license. All right, that will conclude this matter.
Thank you, Judge.
Mhm.
So Ms. Holly, you really don't have to do a bond order. You can just
Right.
reiterate what he has already on it, but
We're just gonna reset on further notice.
Right. Okay,
Thank you.
all right.
We have position number 8, Mr. Sylvester Wells.
All right. This is case
Let you
number.
know, Judge, the Spanish interpreter is on the line now.
Oh, I do see her. Do you want to, can you? This is not going to be Mr. Coleman's case, so he can go in the breakout?
Yes.
Okay. Good
You're not gonna
afternoon,
be able to
Matt.
go in the breakout room with the individual. He's in courtroom 2.
Yeah, Your Honor, I put him to the back of the calendar. I only have 2 more cases that's in front of him.
Okay. Okay. All right.
All right, I'll just wait.
Okay. All right. We'll get back to you in a second.
Okay.
Okay, thank you.
Thank you.
All right, this is case number 22 CR 001080C. Sylvester Wells, you're charged with 1 count of public indecency with the offense date of February 25th, 2022. Pre-trial, do you have anything?
Your Honor, 36 cycles. Last arrest, March of 2021, for fleeing or attempting to elude police officers and hit and run in Fulton County.
No, I don't even own no car. That's my brother.
Hold on, Mr. Wells, you cannot speak at this point.
Record indicates that's an open case, 21 CP 198762. He has, within the past 10 years, 2015 obstruction of law enforcement officers and driving while license suspended, and a 2010 possession of marijuana and driving while license suspended. He has a 2013 felony conviction for possession of cocaine with intent to distribute, 2 violations of probation, and 1 failure to appear within the past 10 years. Nothing further.
All right, thank you. Mr. Berger,
Thank you, Your Honor. The state is asking for a $10,000 cash bond and for this case to be reset for a competency hearing. My office has been speaking with the DA's office. I do know that they plan to file a motion to revoke the defendant's bond, I'm assuming for the felony fleeing from March of 2021. Your Honor, the reason why we're coming in so high with this $10,000 cash bond is quite precisely because of the competency problem. This defendant, according to the victims in this case, has had a problem with masturbating in public on his porch. And it's gotten to the point where there's a potential for major violence. The victim counts at least 3 incidences where the defendant was chasing women down the street with his penis exposed. There are 36 cycles in this defendant's history, and it's rife with violence, DUI, and drugs. This is a dangerous defendant, and it would not be good to have this defendant back out, back at home, and back masturbating on his porch. Along with the conditions of a $10,000 cash bond, the state is asking for a stay away from 816 Kirkwood Avenue, no further contact with Taylor Pack and Rivs Hiles, a mental health evaluation and psychosexual treatment, and no guns, drugs, and alcohol while on bond. Your Honor, again, this is a defendant that we do think has potential for danger. I'm not convinced that a surety bond will ensure that this defendant follows through with any treatment. If this defendant comes back, I just don't think that's possible, given this defendant's history and given his mental health situation at this point. And we do think that a $10,000 cash bond and a reset for a competency hearing would be appropriate for this matter. Nothing further from the state.
all right, and tell me this, the 816 Kirkwood, is that, whose address is that?
That currently is the defendant's address, but the way that he's been in the neighborhood and the way that he's been acting in the neighborhood is not in the best interest of the neighborhood to bring this defendant back. I mean, again, 3 separate occasions where he's chasing women down the street with his penis exposed. That's dangerous, and that's a serious problem. And we do not think that the defendant should be allowed to return to his address. He's lost that privilege.
Okay,
Your Honor, I disagree that Mr. Wells has lost the privilege of living in his own house. I spoke to him extensively today. I did not think he needed a competency evaluation. He did tell me that he had recently been admitted to the hospital, Peachford Hospital, and he did have a diagnosis, and that he recently received medication. And he said that he started taking medication when I talked to him today. He sounded lucid. I was able to speak to him. I didn't have any issues. He said that the medication has been helping. I don't understand the state's argument that about a cash bond. If the DA's office is trying to revoke his bond, then that's for that case. However, for this case, if the state wants him to be supervised by someone, if he gets out on a cash bond, then he would not be supervised by anyone. If he gets out on a surety bond, he would at least have a bonding company to keep tabs on him. So we would ask for a surety bond for that reason, and ask that he not be banned from his address. Any conditions about continuing to take his medications, see his doctor, even sign a release of information about that, that would be perfectly reasonable. And I would also like to add, as far as money goes, based on his recent diagnosis, He has applied for SSI. That application is still pending, and he currently does not have any money right now. So it sounds like there are certainly mental health issues. He has been diagnosed and has started working on it.
In your honor, I would just like to add some clarification. First off, well, several points of clarification. The fact that the DA's office is revoking the bond does not make it mutually exclusive that we cannot ask for a cash bond. It's not like there's some rule that forbids the state from asking for a cash bond just because the DA's office is revoking the previous bond. And again, that bond even has not been revoked. So your honor is still allowed to impose a
I
cash
didn't
bond.
say otherwise.
Anyway, moving forward, I understand. Moving forward, the defendant lives across the street from the victim, and the entire community is afraid of this man. Again, he's masturbating on his porch. This isn't an isolated incident. This has been occurring throughout the years. And the victim has videos. He's chasing women down the street. Families and children are afraid of this man. And finally, this defendant, he doesn't even own the home. It's his mother's home, and he does not have a proper support system. We've even heard from the PD's office that he's been in and out of the hospital and that he's trying to get treatment, but lo and behold, the treatment hasn't gone through. It hasn't worked. This defendant is dangerous. He has violence in his arrests. He's acting violently now. It's necessary for a cash bond to be imposed in this situation. It's an absolute danger to this community.
I did say that he recently got a diagnosis and has started receiving treatment. I don't appreciate the state misrepresenting members to the court.
Okay. I'm not going to advise you to speak, Mr. Wells. I know you're raising your hand. You need to defer to your attorney, Bronstein.
Mr. Wells, if there's any questions that you have, someone from the public defender's office will be out to speak with you. I do not advise you speaking in court right now.
Can you hear me right now?
I don't think you should talk right now. Please don't.
But none of those charges that you just read off on me. The only one is indecent exposure. All the rest of them, not me. I haven't even been in jail.
Okay.
I haven't been in jail for anything.
Okay, so Mr. Wells, GCIC sometimes, especially if there's family members, there might be some crossover or some issues where
every charge that she just named, none of them wasn't me except this.
Right. I was about to say that certainly that happens with family members, unfortunately, somewhat frequently, that GCICs are wrong. So that is certainly something that our office could look into. And to the court, yes, Mr. Wells does say that some of those things are not his. So we would like the court to take into consideration the fact that GCICs are not always 100% correct.
In your honor, I understand that you've likely made your decision, but I just want to reiterate those one point that this defendant is on probation for cruelty to children in the first. He's given 9 years probation. So I would just like to reiterate that even though this incident of pleasuring yourself is not inherently violent, this defendant is a violent individual. He's been convicted for violence. He has violence on his history. And it's also been noted from the victims that this defendant uses an alias. He sometimes refers to himself under his brother's name. So that also causes
none of the cases are mine. Why would I refer to myself?
Mr. Wells, please stop talking.
They're not my cases. You reading out stuff that's not mine.
Mr. Wells, I'm going to ask you to be quiet, please. We have heard you and we've heard from your attorney, but I'm ready to give my ruling. I guess one last question, Ms. Bronstein, and not for sure if it's going to matter a whole lot. Does this defendant have somewhere else to go stay?
I did not ask. He gave me that address as where he was staying.
Yes.
You have somewhere else to go stay, Mr. Wells?
Yes.
Fine. All right, I'm going to order a $5,000 cash bond. I'm going to order a stay away from 816 Kirkwood. I'm going to order no further contact with the victim's Taylor Pack. And I didn't write down the name of the second victim. Who was the second victim, Mr. Borger?
Thank you, Your Honor. The second victim is Mr. Rives Hiles, Rives Hiles.
Okay. I'm going to also order with this $5,000 cash bond, Mr. Wells, again, that you stay away from that Kirkwood address. I am a little alarmed about your conduct in the community there. And
That was before I got checked into the hospital and started my treatment.
okay,
All that happened on one little incident. All that was one incident, and then I got checked into the hospital for that stuff right there.
okay,
And
Mr. Wells, please don't speak anymore. Because these are not statements that are to your benefit at this point. I also want to state that I'm going to order an inmate psychosexual evaluation, as well as you following the treatment that's laid out in this plan, or continue on as well with your medication and treatment that you're presently receiving. But I do want you to have the evaluation, evaluation as well, and to continue with your medication and treatment if you get out on this cash bond. No drugs, alcohol, or weapons while on bond. And as I stated, you'll need to find somewhere else to live and not go back to your mother's house or that address, or else you can be immediately arrested, especially if the victims see you over at that address. So you need to stay away while you're on bond if you get out on bond. All right?
Yeah,
Thank you. Nothing further.
yeah.
Your Honor, we have position number 10, Mr. Eugene Willingham, position number 10.
Your Honor, what is the reset for that last position, Mr. Wells?
Oh, that will be March the 10th.
Okay, and so there will be no competency hearing?
Oh, as far as awarding that, I'm not going to order the competency hearing, just the inmate psychosexual.
Okay, thank you, Your Honor.
Okay, thank you. All right, this is position 10, did you say?
Oh,
Who do I have before me?
That's Mr. Willingham, Your Honor, position number 10.
Okay, I was making sure.
Yeah.
This is 22 CR 001081H. Eugene Willingham, you're charged with 1 count of possession of marijuana less than an ounce with the offense date of February 25th, 2022. Do you have anything pretrial?
On the 17 cycles, last arrest, August of 2021 for probation violation in Fulton County. Underlying charge is possession of cocaine. Record indicates the defendant has an open case pending in Fulton County for possession of cocaine with intent to distribute, possession of marijuana, violation of Georgia Controlled Substance Act, possession and use of drug-related objects, case number 21 CP 202332. Additional open case for criminal trespass 20 CR 000339 B like boy. Record indicates the defendant is also on probation in Fulton County for manufacture, possession, distribution of controlled substance in drug-free zone, possession and manufacture or distribution of or sale of marijuana, 18 SC 163772. Sentenced January of 2019, 3 years probation. Record indicates the defendant has 3 violations of probation within the past 10 years. Nothing further to add.
All right, Mr. Borger.
Thank you, Your Honor. The state would consent to a $1,000 signature bond with the conditions of no guns, drugs, or alcohol while on bond.
Okay.
Your Honor,
Yes, Ms. McLeod.
we have no objection to what the state is asking.
Okay. And Ms. Harrison, I'm assuming this would not be a signature bond through pretrial.
He was not recommended for pretrial, Your Honor, but one moment. I have no problems taking it. It will be per judge.
Right, I'm going to order the $1,000 signature bond through pretrial per judge. No
Thank
drugs,
you, Your Honor.
no drugs, alcohol, or weapons while on bond. And I think that will conclude this case. Anything else that I need to take up?
Nothing further from the state, Your Honor.
Okay.
Thank you, Your Honor.
right,
That concludes
yeah.
my business before the court today. May I be excused?
Yes, you may. Thank you.
Thank you.
Next, we have the South Annex, Your Honor, with position number 9, Priscilla Williams.
All right. This is
Judge, at
case,
this time- I'm sorry, Judge, is courtroom 2, they were going to breakout room for the Spanish interpreter and Mr. Coleman?
Yeah, we can now, Your Honor.
What did he say?
We can.
Okay, I just wanted to make sure before I put him in there.
all
Okay.
right, there's Mr. Coleman. Okay,
I'm ready.
all right.
You got this Spanish interpreter. She's gonna talk to you now, okay? Un momento.
Nos van a poner en una sala, nosotros no la vamos. I'm sorry, Your Honor. I was just translating for Mr. Coleman.
Okay, make sure you mute yourself, courtroom 2, while I handle the South Annex. All right, this is case number 22 CR 000-984J. Case with Priscilla Williams. You're charged with 1 count of battery with the offense date of February 22nd, 2022. Ms. Harrison, do you have anything from pretrial?
9 cycles with history in Georgia and Oklahoma. Last arrest, November of 2021 for criminal trespass in Fulton County. That was a conviction. Record indicates 1 failure to appear within the past 10 years. There's a 2016 felony conviction in Oklahoma for assault battery with deadly weapon, battery and police officer, cruelty to animals, and unauthorized use of vehicle. Record also indicates 2 felony convictions in 2011 in Fulton County for obstruction of law enforcement officers, 2 counts, both in 2011. Nothing further, Your Honor.
All right, Mr. Borger.
Thank you, Your Honor. The state's asking for an $8,000 surety bond with the conditions of no further violent contact with Miss Karen Hargrove. That's last name spelled H-A-R-G as in Georgia, R-O-V-E, V as in victory. Mental health evaluation and treatment, and no guns, drugs, or alcohol while on bond. Your Honor, in this case, the victim here, Miss Hargrove, she's a nurse working over at Grady, and she was serving the discharge papers to Miss Williams when Miss Williams overreacted and hit Miss Hargrove in the head and pulled her hair. According to Miss Hargrove, she believes she may have suffered perhaps a concussion and has experienced some brain injury to her head.
The charges in Oklahoma, I just got out of
No,
prison.
no. Hold on, Miss Williams. Please do not speak.
I just got out of prison for
No, do not speak. All right.
The Miss Hargrove suffered again, I believed a mild concussion, and so this could make this case a felony. Looking at the defendant's history, again, it's also rife with violence. There's aggravated assault from 2011, battery of a police officer, cruelty to animals in 2016, and that's out of Oklahoma. So given the fact that this defendant is a repeat violent offender, is a defender with, I suppose, significant out-of-state ties, given that she had lived in Oklahoma for some time, the state does believe that a surety bond would be appropriate in this situation. Nothing further from the state.
All right. Ms. Bronstein?
Thank you, Judge. I would ask that the court set a reasonable bond in this case and reset Ms. Williams for the March 10th competency status calendar. I have already sent Ms. Bridgewater a referral motion and order. I have spoken with my supervisor about this and also Ms. Williams, and all three of us would like her to get evaluated. She does have several mental health diagnoses. And she, due to her lack of health insurance, has not had stable and consistent care or medication regimen. And right now she is taking fewer medications than she has and is not doing well. And says that she wants to go. I think she had been taking 8 and now she's down to 2, and it's really just, as we can see, not going well. So as I said, I would ask the court set a reasonable bond and place her on that competency status calendar and sign the motion order that I sent over.
Okay.
I'm sorry, Judge, for that interruption, but any way I can talk to you and PD and ACG, I have some information. I can't really type into the text in the chat right quick.
Okay.
I'll do that right quick.
Okay. All right, I have heard from the state in this matter. Ms. Bronstein, is there anything that you would like to state?
No, Your Honor, we're just asking that a reasonable bond be set and that she be placed on the March 10th competency calendar and that the court sign the order.
Okay. All right. Ms. Williams, I'm going to order that you receive a $10,000 surety bond. I'm going to also order that you have no further contact with Carolyn Hargrove, the nurse at Grady. I'm going to order MHET, and I'm going to reset your case to the March 10th competency calendar. And no drugs, alcohol, or weapons if you make bond. All right.
Judge, was that no further contact or no further violent contact?
I'm
Thank
going
you for that
to,
question.
well, I'd had to honestly, I know that they asked for no further violent contact, but if she has to go to Grady, unfortunately, they will have to
Right.
have, someone else to treat her.
Okay,
So I'm just gonna order no further contact with
Not a
that
problem.
nurse, yes.
okay, no problem.
All right, that should conclude this case.
Thank you, Judge.
Thank
May
you.
we be excused, Your Honor?
Yes, you may, thank you.
Thank you.
Yeah, what was the bond on Miss Williams you just said?
That was a $10,000 surety bond.
Okay, thank you.
Uh-huh. All right. Who do we have next in courtroom?
I think all we have left is the Mr. Estrada Lopez and Mr.
Dorsey,
Dorsey.
Okay,
Mr. Dorsey, he bonded out.
thank you.
okay.
Okay. Well, then we would just have Mr. Estrada Lopez then.
Okay, good. All right, Madam Interpreter, can you raise your right hand for me, please?
Yes, Your Honor.
Do you solemnly swear or affirm that you will faithfully interpret from English to Spanish or Spanish to English?
I do.
The proceedings before the court in an accurate manner to the best of your skill and knowledge with no embellishment?
I do, Your Honor.
All right, state your name for the record.
Lucia Urtuzastegui, and that's URTUSASTEGUI.
All right. This is case number 22 CR 001076D. Mr. Adelso Estrada Lopez, you're charged with 1 count of theft by taking with the offense date of February the 24th, 2022.
Señor Alonso Estrada López, este es el caso número 22 CR 1076D. Está siendo acusado usted con una acusación de robo al tomar que sucedió el 24 de febrero del 2022.
All right, pretrial, do you have anything?
Just one arrest, January 2019 for alien inadmissibility. This is his second arrest. He is recommended for UJR through pretrial.
Okay. All right, Ms. Sari.
Yes, Your Honor. In this case, the defendant was seen on camera taking a Lenovo laptop, AirPod Pro, Jordan shoes, and a Smith & Wesson 9mm pistol and putting it inside his backpack.
He's interpreting. She's interpreting.
Oh, I'm sorry.
Yeah, better slow down a little bit. I know she's good though.
La acusación es hecha porque se le tiene grabado en cámara que usted tomó una computadora Novo, una pistola Smith Wesson y también un par de zapatos de Jordan y que los guardó. Go ahead.
The items belong to the victim, Adrian Gregory.
Esas cosas fueron, el dueño de eso es la víctima que se llama Adrian Gregory.
And his name is spelled Adrian, common last name for Gregory, common spelling.
What was the location?
Okay, yes, Your Honor, the location was 33 South Main Street in Alpharetta at Up on the Roof. That's the name of the establishment.
Esto sucedió en el 33 sur de la calle calle Main Street en Marietta, en un lugar que se llama Up on the Roof.
Your Honor, the defendant did admit to taking the laptop and the shoes. He stated, however, he did not take the pistol and the AirPods.
Que la persona que usted se declaró, dijo que sí había tomado la computadora y los zapatos, pero que no había tomado la pistola y los AirPods.
¿Puedo hablar?
Can I speak?
No, sir.
No en este momento todavía.
Your Honor, due to the facts stated above, the state is recommending a $5,000 surety bond.
Debido a los hechos que se han presentado, el Estado, la Fiscalía está diciendo que se le dé una fianza de $5,000.
And Your Honor, the reason we're asking for a $5,000 surety bond is because of the allegation of the pistol being stolen, but the defendant not having admitted to where it is.
Y la razón por la que se le está dando la fianza de $5,000 es por haber tomado la pistola y no admitir dónde está.
No contact with the victim, Adrian Gregory.
Se le pide aparte ningún contacto o comunicación con la víctima, Adrian Gregory.
And to stay away from Up on the Roof.
Y el no regresar nunca a Up on the Roof.
Nothing further, Your Honor.
Okay. Mr. Coleman?
Your Honor, I would be requesting a signature bond from Mr. Estrada Lopez.
Este es su abogado defensor, bueno, el que le está defendiendo hoy, y dice que está pidiendo una fianza para el señor Estrada López.
He is 47 years of age.
Tiene 47 años de edad.
He is the father of 3 children, ages 8, 11, and 15.
Es el papá de 3 niños de la edad de 8, 11 y 15 años.
He has lived here in Atlanta, Fulton County for the last 2 years.
Ha vivido aquí en Atlanta, en el condado de Fulton, por los últimos 2 años.
He has lived with a roommate here for the last 5 months.
Y está viviendo con otra persona. Están compartiendo donde vive como por 5 meses con esa persona.
He does also have a brother living here in the city.
También tiene un hermano que vive aquí en la ciudad.
I will remind the court at this time that these are just allegations against Mr. Estrada Lopez.
Quiero recordarle al tribunal que estas nada más son alegaciones en contra del señor Estrada López en este momento.
This is only his second arrest, nonviolent offense.
Este es únicamente el segundo arresto sin ninguna ofensa de violencia.
So we will be requesting a signature bond.
Entonces vamos a pedir que la fianza no sea en dinero, sino nada más con la firma.
Do we know whether did Mr. Estrada Lopez work at this location, or was he just a patron? Does anybody know that?
He does work at a place called Tavern. He doesn't know how to spell it. I don't think that this is the same location. I'm not exactly sure, but I don't think it's the same location.
Okay.
And I don't have any information about his employment history either, Your Honor.
Okay. Well, I didn't know if the report reflected whether he worked there or was just a patron there at the Up on the Roof.
Yeah.
No. I'm sorry, Your Honor. Do you need me to ask him that?
Let's ask him real quick. Yes.
Okay, los abogados no saben si es que usted estaba en Up on the Roof porque trabajaba ahí o nada más era cliente. ¿Puede aclarar eso?
¿Cómo?
Que si usted estaba en el establecimiento de Up on the Roof porque usted era cliente o trabajaba ahí.
Oh, yo trabajo ahí en el restaurante. Trabajo en el restaurante y o sea que yo iba a sacar basura ese día. En la noche,
Espérame un ratito. I work at the restaurant. I was about to take the trash out that night. He wanted to tell the story of what had happened.
Okay, I'm not advising you to speak any further, Mr. Lopez.
Ok, señor López, en este momento no tiene que decir nada más.
So that's what I was wondering. And I got that answer that he does work there. I don't know that I want him to go back there if this is items alleged to have been taken from a patron or coworker.
Well, if this is his place of employment, as far as I know, he hasn't been terminated. So I would like for him to preserve his job if possible.
And Your Honor, if I may, he was seen on video by someone there. So I will just ask you to take that into consideration as well.
Well, again, if he's been terminated from there, that's one thing. I would have no objection to him returning. But again, if that is his job, if that's his livelihood, his way of supporting himself, then obviously I would like for him to be able to return there to work.
Y lo que la abogada acusatoria está diciendo es que ellos están pidiendo que no regrese ahí, pero su abogado que le está defendiendo está diciendo que si es que no lo han despedido, entonces usted debería poder regresar a su trabajo.
gracias, le agradezco porque ese es mi lugar, pues que tengo mi trabajo y como que puedo ganar.
All right, thank you. I would like that because that is my job and that's where I make my money.
That is a difficult decision. I'm going to order.
Again, I'm not exactly sure who this Adrian Gregory is, unless he's the owner. If he's just a patron at that time, then it's unlikely that he would come back in contact with my client anyway. I mean, it's not been alleged that this Mr. Gregory is my client's employer or coworker.
No, we haven't alleged that, Your Honor, but if he is at the at his job taking items, he was seen on camera by an employee there. This wasn't something that was reported by the victim themselves. It was reported on by someone on camera.
Yeah, and again, I do understand that, and certainly if he has been terminated from that position, he has no reason to go back, but I have no reason to believe that he's been terminated. So if his employer is still, if he still has a job there, I would like for him to be able to return to his job. If they want to terminate him afterwards because of this, that's one thing, but if he still has his job there, I would not want him to be kept away from his job.
Can I ask one question? Ask him if he knows who this Mr. Adrian Gregory is. Does he know that the victim, or does he know who that is? Can we ask that question, please, Mr. Coleman?
Yes.
Okay.
If the interpreter could answer him that question.
Yes. Señor Estrada, ¿sabe usted quién es este señor Adrián Gregory?
No, yo no sé quién es él, porque yo trabajo en el lugar de abajo y aún no sé pero ni quién había dejado esa maleta, porque cuando...
Okay, ahí nada.
Afuera.
No, I don't know who that is, and I work on the lower level, and I don't know who had left that bag there.
All right, I'm going to order the $5,000 signature bond through pretrial. I'm going to order that he have no further contact with Adrian Gregory, Mr. Adrian Gregory, whoever that is. We know it is the victim in this case. No drugs, alcohol, or weapons while on bond. I'm going to order that he take a theft class while on bond. As far as returning to the location of the up on the roof, Alpharetta on Main Street, I think that I'm going to order that he stay away from that location while on bond. And if he can find a different job or another job, because I just don't want him to go back there to, while he's on bond, to be accused or to get in trouble or, you know, end up back in jail. So I think for the temporary time, unfortunately, Mr. Estrada Lopez, you need to stay away from 33 South Main Street up on the roof while you're on bond.
Your Honor, will he be allowed to return there and work unless his employer terminates him? Because again, I would hate for him to lose his job, particularly in this economy during a pandemic.
What's the state's position on that?
Your Honor, the state just reinstates our position, stay away from the location.
Yeah, again, I don't have any objection to him being kept away from this location if he's been terminated. But I have no reason to believe that he's been terminated from his position. If this was just a patron at this establishment at the time, it's highly unlikely that he would come back in contact with this person. You've already ordered that there be no further contact. I just see no good reason to keep him away from his job. Now, again, if his employer has terminated him, that's certainly no reason for him to go back. But if he still has his job there, then he's going to lose his job, Your Honor, if he's not able to go back to work.
Your Honor, if I could just have one moment to speak with the supervisor regarding this, please.
Okay.
Thank you.
Hold for a second, Mr. Coleman and Madam Interpreter.
Vamos a esperar un momento porque la abogada acusatoria tiene que hablar con un supervisor.
Okay.
Does anyone know if they offer this step class in Spanish?
I don't know where, but I have heard in courts that it is offered in Spanish somewhere. I'm not sure where though.
Okay.
And we don't have an employer, any victims or anybody on that case. I know we had that one number, but it looks like it's fallen off, that we didn't know who it was.
Your Honor, if we could just have one more moment where actually I have someone on the phone with the restaurant now.
Okay.
Thank you. Your Honor, this defendant works for Tapper's Tavern and not Up on the Roof. So they are two different locations, two different business establishments. However, given the amount of time we have spent with this case, we'll continue to investigate and we'll defer to you for your discretion on whether to issue the stay away or not.
I think he did mention he works at the lower level, which may be a different restaurant. It sounds like it's maybe 2 levels. I'm not familiar. So what I'm going to order, again, this $5,000 signature bond through pretrial. I am going to order that he stay away from the Up on the Roof restaurant or location at 33 South Main Street. If the defendant works at a different restaurant or different part of the establishment, as you stated, the Tapper Tavern, he can return there, but not to Up on the Roof. He's
Yeah,
not.
but may I inquire from Mr. Lopez?
Okay.
Mr. Lopez, do you work at Up on the Roof on Main Street?
Señor López, ¿trabaja usted en el restaurante Up on the Roof que está en Main Street? ¿Es ahí donde trabaja usted?
¿Cuál?
Up on the Roof. ¿Trabaja usted para el restaurante Up on the Roof en Main Street?
Yo trabajo en el que se llama el Tapper Taberna.
I work at Tapper Tavern.
Okay, so if the judge orders that you not go to Up on the Roof on Main Street, that will not be a problem as far as your job is concerned?
Entonces, si es que la juez le ordena que usted no puede ir al restaurante Up on the Roof, ¿eso no es problema para usted en cuanto a su trabajo?
Pues bien es problema, porque, o sea que es donde yo, tal vez hay otro mi trabajo, pero se me hace ganar poquito, tal vez de unos $300, $400
I don't think he heard the question. Escuche bien la pregunta. La pregunta es, ¿puede usted ir a su trabajo en el restaurante en el que trabaja sin ir a Up on the Roof?
Claro que sí, o sea, pero no, o sea, sí puedo ir. Nada más ahorita lo que falta es que me den mi trabajo, ¿no? Pero yo voy a hablar que me lo den, pues, porque no es problema mío, nada más que la persona me acusó mal. Ujú.
Okay, yes, I can stay away because it's another restaurant. I work for Taffer's Tavern. That is not the same restaurant, although it's above it. But I can go back to my job.
Okay, that's fine then. Thank you.
Okay. All right, so we're going to make sure that he is clear that he is ordered to stay away from the part of the establishment that is up on the roof. He is to have no drugs, alcohol, or weapons while on bond. And he can go to his job as long as it requires or allows him to stay away from up on the roof at 33 South Main Street.
Okay. Entonces, lo que la juez le está, lo que está la juez dictando es lo siguiente. ¿Me escucha?
Ajá, le escucho.
Le van a dar una fianza de $5,000. Únicamente tiene que firmar, pero no dar el dinero, sino que firmar, pero va a estar bajo fianza hasta que se presente al juicio. ¿Ok? Durante ese periodo de tiempo que está usted bajo fianza, no puede tener ningún contacto con el señor, con la víctima, el señor Adrián Gregory. Tampoco puede tener nada que ver, ni puede estar en ninguna parte del restaurante Up on the Roof en el 33 de South Main Street en Alpharetta. Le van a hacer que vaya, tiene que ir a tomar una clase anti-robos. Y no puede regresar a ese restaurante de Up on the Roof, como le dije. Esas son las condiciones y lo que la juez está dictando.
Okay.
¿Escuchó? Okay.
Sí.
Okay.
Pero siendo así que no pudiera regresar, yo tendría que ir la manera de buscar otro trabajo, por otro lado. Si es de que no sé si está tan cerca el trabajo donde, digamos, de ese otro trabajo que me habla de trabaja la persona. Ajá.
I'm not sure if the person works at that other restaurant. I don't know that.
Your Honor, we were able to find out that the victim does work for Up on the Roof.
Say that again, Ms. Sorry.
Sorry, but we were able to confirm that the victim does work for Up on the Roof, the incident location.
Oh, the victim does. Okay.
Yes.
All right. Well, so he has to stay away from the victim, Mr. Adrian Gregory, and he has to stay away from the Up on the Roof. So if he does that, then he would not be violating his bond.
Como I'm sorry. Go ahead, Mr. Coleman.
I was just saying thank you.
And let me ask one thing, Judge, you had said take an anti-theft class. Is that still part of the condition or no?
Yes.
Okay.
Señor Estrada, tiene que, como parte de la condición de la fianza, necesita mantenerse alejado del señor que trabaja ahí en ese otro restaurante, Adrián Gregory, y necesita mantenerse alejado del restaurante Up on the Roof. ¿Ok? Esa es condición de su fianza. Si viola esa condición, lo van a arrestar.
Ok. Pues yo acepto de todas maneras como quiera, o sea que no, todavía no, hasta en la otra, en la otra tal vez se va a ir aclarando todo, porque es lo que yo quiero que se vaya aclarando. Ajá.
Okay, I accept that, but I do want to clarify all of this. So would that happen the next time I'm in court?
Or what happened? I'm not for sure if I understand what the question is. He has heard his bond conditions. He can speak with his attorney if he has any additional question.
Usted ha escuchado y ha entendido las condiciones de su fianza. Cualquier otra pregunta o que usted quiera hacer necesita consultar con su propio abogado.
Ok.
Okay.
Está bien, ya las entendí.
I understood.
All right, that concludes this case.
Pregunta más quiero como mi abogado, ¿no? Ujú.
Everything else, I'm gonna need to get an attorney. I understand.
Yes, thank
Okay.
you.
Thank you. All right.
Okay, gracias. Eso es todo, señor Estrada.
All right, thank you. You may be
Thank you,
excused.
Madam
Appreciate your
Interpreter.
time. All right, thank you.
Okay, thank you.
Okay, I think that was the last case. Should we go over
Yeah.
the calendar now?
Yes, ma'am.
Okay, again, the reset date for SAP is March the 10th. Okay, position number 1 is being reset further notice with a $2,000 SOB through pretrial. Position 2 is reset further notice with a $2,000 SOB through the jail. Position 3 is reset to the SAP calendar with a $2,500 good bond. Position 4 bonded out, so therefore it will be reset further notice. Position 5 is reset further notice with a $5,000 SOB through pretrial. Position 6 is reset to the SAP calendar with a $5,000 total good bond. Position 7 bonded out, therefore it will be reset further notice. Position 8 is reset SAP calendar with a $5,000 cash bond. Position 9 is being reset to March 10th for the competency calendar with a $10,000 good bond. And position 10 is reset further notice with a $1,000 SOB through pretrial per judge. Are there any questions, corrections, or comments? No?
Nope.
Enjoy the rest of the weekend. How about that?
Enjoy, everybody. Have a good
Yes.
day.
Have a
Thank
right.
you. Everyone have a good
Good night.
weekend.
You
What's
too.
left of it.
Yeah.